Last 5 seconds. Ready? Start. It must be noted here that though in the FIR a case was made out that deceased Harpal Singh died to bullet injuries caused by bullets fired by accused to Yad Prakash in the evidence, the prosecution witnesses and in particular PW1 deposed that due to commotion caused by firing of shots by accused to Harpal Singh fell down and later on he was attacked by the other accused. The injuries caused by sharp weapons led to his death. Apart from the evidence of recovery, the prosecution mainly relied upon the evidence of eyewitnesses of PW1 Atar Singh and PW2 Malkhan Singh, who were allegedly injured at the hands of the accused. Shri Rakesh Khanna, the learned senior counsel appearing for the appellants, pointed out at the outset that one of the five accused, Diwan Singh, has been acquitted by this court and therefore only four accused were involved in the incident. He therefore submitted that the allegation of unlawful assembly made by the prosecution cannot be accepted as there was no assembly of five or more persons. He therefore submitted that sections 148 and 149 IPC could not be invoked. He invited our attention to the fourth charge framed against the accused. He pointed out that the said charge alleges that accused to Yad Prakash opened fire with a country-made revolver and bullet injury sustained by Harpal Singh caused his death. He pointed out that there was no charge framed that the accused killed Harpal Singh after he fell down by using weapons in their hands. He submitted that, as can be seen from the judgments of the Sessions Court and High Court, it has been held that Harpal Singh did not receive any firearm injury but he suffered injuries due to the assault made by accused 1, 2 and 4 by weapons in their hands. He submitted that the accused were misled due to the failure to frame proper charge. He submitted that though PW1 and PW2 deposed that Harpal Singh is not the victim of bullet injury caused by the firearm used by accused 2 while recording statements of the accused under section 313. The only circumstance put to the accused is that Harpal Singh died due to 4 to 5 shots fired by accused to Yad Prakash. He pointed out that the circumstance that the accused attacked Harpal Singh with the weapons in their hands, which ultimately caused the death of Harpal Singh, has not been put to the accused persons. He submitted that a serious prejudice has been caused to the accused due to the failure to frame proper charge and by failure to put material circumstances to the accused in their statement under section 313 CRPC. He therefore submitted that the conviction of appellants 1, 2 and 4 is vitiated and they deserve to be acquitted. He also pointed out that the applications for a grant of exemption from surrendering made by the appellants were rejected by this court by order dated 29 July 2019. The custody certificate show that appellants 1, 2 and 4 are in custody since 19 August 2019. Shri Vinod Divakar, learned additional advocate general for the state of Uttar Pradesh, firstly submitted that the advocate for the accused had cross-examined the material prosecution witnesses, including the two eyewitnesses on the prosecution case that Harpal Singh died due to assault made by appellants 1, 2 and 4 by the weapons in their hands. Therefore, there was no prejudice caused to them on account of the failure of the court to frame a proper charge. Moreover, the appellants were aware of the prosecution case as reflected in the evidence of PW1 and PW2 and therefore The failure of the learned trial judge to put the circumstance to them in their statement under section 313 is not at all fatal. He submitted that both the courts have believed the testimony of PW1 and PW2. He submitted that injuries on the person of deceased Harpal Singh and injuries found on the injured persons including PW1 and PW2 were consistent with the prosecution case. He would therefore submit that no interference is called for in this appeal as two persons have been brutally murdered and several other were injured. Stop.